my lord, we were on section 49, subsection 6. Page
That's
7, my lord.
violation.
Compilation volume 1, page 7, my lord.
Uh,
Page 7, at the
page
top, kindly see, my lord.
yes, section 49.
The balance in the electronic cash ledger or electronic credit ledger after payment of tax, interest, penalty, fee, or any other amount payable under this act or the rules made thereunder may be refunded in accordance with the provision section 54.
Yes.
54 is the only provision which deals with all refund. I will take your lordship to that. Then, my lord, I am escaping all other provisions which are not relevant for the issue that is going to be which is being raised by us. So, my lord, just come to the bottom explanation.
Yes.
For the purpose of this section,
Yes.
for the purposes of this section, the date of credit to the account of the government in the authorized bank shall be deemed to be the date of deposit in the electronic cash ledger. So, my lord, I am trying to make out a point. The money, in fact, is going into the account of the government. Then, my lord, turn to page 50, section 54, which is on page, my lord. Page 10, my lord.
Yes.
The amount lying unutilized in electronic cash ledger, which has gone into the government account, can be refunded, but it's short to section 54. 54 it reads, my lord. Page 10, bottom para, my lord. Refund of tax. Section 54, section 1. Any person. What, my lord? What, my lord?
Yes.
Any person claiming refund of tax or refund of any tax and interest, if any, paid on such tax or any other amount paid by him, may make an application before the expiry of 2 years from the relevant date in such form and manner as may be prescribed. My lord, I will pause for a while. I would ask a question to myself. If I don't apply within 2 years, it is my money, then what will happen, my lord? Where ultimately the money will go. In fact, the money is already lying in the coffers of the government. And the moment 2 expires, I lose that amount. Then, my lord, come to next page. Provided that a registered person claiming refund of any balance in the electronic cash ledger in accordance with the provisions of section 6 of section 49 may claim such a refund in the return furnished under section 39 in such manner as may prescribe. Then can I turn to next page, my lord. Page 13, my lord. So section 2 is not relevant. It is for a specialized agency like United Nations Organization. I am skipping that, my lord. Then, my lord, 3.
Yes.
Subject to the provisions of section 10, a registered person may claim refund of any unutilized input tax credit at the end of any tax period, provided that no refund of unutilized tax credit shall be allowed in cases other than zero-rated supplies made without payment of tax. Zero-rated means, my lord, mainly export.
Yes.
Where the credit has accumulated on account of rate of tax on inputs being higher than the rate of tax on output supplies, other than nil-rated or fully exempt supplies, except supplies of goods or services, or both, as may be notified by the government on recommendation of the council, provided that no refund of unutilized input tax credit shall be allowed in cases where the goods exported out of India are subject to export duty. Provided also that no refund of input tax credit shall be allowed if the supplier of the goods or services or both avails of drawback in respect of central tax or claims refund of integrated tax on such supplies. The application shall be accompanied by such documentary evidence as may be prescribed to establish that the refund is due to the applicant, and the documentary or other evidence, including the documents referred to in section 33, as the applicant may furnish to establish that the amount of tax and interest, if any, paid on such tax or any other amount, or not the word other amount, paid in relation to which the refund is claimed was collected from or paid by him, and the incidence of tax and interest had not been passed on any other person, provided that where the amount claimed my lord, the word amount as refund is less than 2 lakh rupees, it shall not be necessary for the applicant to furnish any documentary or other evidences, but he may file a declaration based on the documentary or other evidences available with him, certifying that the incidence of such tax and the interest has not been passed on to any other person. Then 5. If on receipt of any such application, the proper officer is satisfied that the whole or part of the amount claimed as refund is refundable, he may make an order accordingly, and the amount so determined shall be refunded to the fund referred to in section 57. My lord, just I will pause for a while. What is the fund? This is Consumer Welfare Fund. Initially, it says that the refund will not be made to you directly. First, you have to prove that there is no unjust enrichment. You have not passed the burden of this amount to a third person. If that succeed in proving, then the money will be refunded to you, or else the money will go to the consumer welfare fund. Money is being transferred from the government to
When
the
you
fund.
talk about refund in connection with cash ledger, then there is no question of unjust enrichment because it is not a part of input tax credit.
No, my lord, subsection
Cash
5,
ledger, when you
subsection
deposit
5,
amount in cash, when you
subsection 5.
deposit amount in cash, there is no trapping of any kind of unjust enrichment in cash.
But I have to cross that barrier. I have to cross that barrier, my lord.
The entire gamut is applicable only when the payment is made to the government or the claim is on account of refund of ITC.
No, my lord. The section doesn't say so. Plain language doesn't say so. Payment to the government, explanation 249 says it is a payment to the government. Now, from the government coffer, money will either come to me or will go to the fund. If I succeed in proving that the instance is not passed, then it will come to me. If I fail in proving that the instance is not passed, then it will go to the fund. If it is my money, it is my deposit, why it will not come to me? It will come to me. It is not my money with me. It's my money with the government. That is why all these restrictions are there. Straight away, I cannot say that it is my deposit with like a balance in the bank and say that my money is with you, give me. It is not that. So, my
Mr.
lord,
Kurmi, the proviso to the section which has been
49, my lord.
added, the proviso to the section which has been added, that the language is very clear and that proviso is not under challenge.
No, my lord, two things. I have got twofold contention. One, that the proviso manifests the legislative intent that the legislature treats the credit as a payment to the government. Payment to the government, when I say, means not tax. I say compensatory nature. The government says the money has come to me, it did not pay any tax. Proviso says that because from the day one, liability may accrue on the 20th of next month, but the credit will start accruing from the day one. Day one. That is why special provision has been made. But when I pay the tax in cash, the legislature intends or the legislature assumes that I'll pay on the cutoff date of 20th. But what when? When I have paid that money beforehand.
Mr. Kurmi, you just see the proviso to section, this section 50. You just tell us that under what circumstances your case or date of credit in the cash ledger will have any bearing on the face of the plain reading of proviso.
Well, that's what I am trying to make out. My contention is twofold. One,
You see, Mr. Kurmi, you are trying to make a classification between a situation where the payment is made much before or payment is made slightly later. But no such classification is contemplated in this proviso.
yes, then we have to see the nature of the levy itself. If the nature of the levy is compensatory, that is manifested from the
You are,
proviso.
see, we are, when you say it is compensatory, we're not with you on that. What do you mean compensatory?
No, my lord, then I will make it out, my lord.
No.
No. Interest is always compensatory.
Interest is itself a levy, and whether it is compensated, it is as per the statute. The interest is payable. Everything is governed by the statute. Does the statute say that it is compensatory?
My lord, that money is claimed from me, the amount of interest is claimed from me on the ground that I have withheld the government money.
That itself is a part of the scheme of the act.
No, my lord, that is a mercenary provision, substantive provision, of course, creating a charge. Charge for what? Because, my lord, if we go back to the constitution, my lord, let me go back to the constitution. And the earlier regime, new regime is slightly different, but
Mr.
the
Kurmi, I am
substance is
sure
one and
that,
same.
just one more sentence. Mr. Kurmi, I am sure that you have read this VKP footsteps judgment of the Honorable Supreme Court.
Yes, I have read, my lord.
You have read it.
I have read it.
You have seen the scheme. The entire scheme of CGST Act is discussed. The entire scheme of refund has been discussed.
No, but that does not touch this issue.
No, you see, the point is that the manner in which the Honorable Supreme Court has interpreted the provision of Section 54 itself, that was the subject matter of interpretation before the Honorable Supreme Court.
My lord, refund 54.
There is no question of any equity.
No, I am not claiming any equity.
So,
I am simply saying, my lord, I am simply saying the nature of levy under 50 is compensatory in character. And I am to compensate the state for the amount withheld by me. If I have not withheld the money, there cannot be any interest. So the nature of interest is compensatory. Supreme Court has said in Particular Procedures. I will take your lordship to that also. There is no debate on that. Now, compensation for what? Money is already lying with the government. Compensation for what? That is my point. This is one leg of my argument. My second leg of my argument is that whether the credit itself can be treated as a deposit with the government or only on debit. So that is I am trying to make out that the credit itself is a amount in the coffers of the government. And when the money is already in the coffers of the government, what interest I am to pay? I am not to pay any interest on that. So, my lord, kindly straight away come to section 54, subsection 7. Kindly skip the 6.1, subsection 7.
Mr. Kurmi, I repeat my question. You just have a look at the proviso to Section 50, right? Does it not contemplate payment of interest on the delay in debit made from electronic cash ledger? How is your interpretation one of the plausible interpretation on the face of the proviso to Section 50? You
My lord,
have
the
to come
proviso,
out of the proviso to Section 50. First, you
my lord,
tell
the
us
proviso
how will
to
you
section
come out
50.
of the proviso to
I will
Section
come to that, my lord. Definitely, I will come to that.
Why is it that the legislature has not included electronic credit ledger but has only included electronic cash ledger?
My lord, the credit in the electronic credit ledger starts accumulating from the day one. Whether you credit it, you don't credit it, automatically it will come to the account. But as far as the cash is concerned, one has to make a deposit. That is why if you are making a deposit delayed, then interest you have to pay. How the provision can cover that? Proviso is not taking care of a situation where the credit is made into the
Proviso
electronic
is
cash.
not talking about credit to be made in electronic cash ledger. It is talking about debit of the amount from electronic cash ledger. The date of crediting the electronic cash ledger is totally irrelevant for the proviso.
Yes, that is my point, my lord. My point is that where there is a credit available in the credit ledger, the ledger say you did not pay the interest. That is my point. That is throwing a light on the interpretation section 51. It says when there is a credit available in the ledger, then you are not required to pay the interest. That is my point. That when there is a credit available in the electronic cash ledger, I am not required to pay the interest. Mind you, kindly read subsection 7 of section 54. Let me complete this, my lord. 54, let me complete. Two sections, subsection only I will read. 7 and 8. 7, my lord, kindly see page 14. 54, 7. Page 14, my lord.
Yes.
The proper officer shall issue the order under subsection 5 within 60 days from the date of receipt of the application, complete in all respect. Then, my lord, turn to next page. Page 15, subsection 11, my lord. Where an order giving rise to refund is subject matter of an appeal or further proceeding, or where any further proceedings under this act is pending, and the commissioner is of the opinion that the grant of such refund is likely to adversely affect the revenue in the said appeal or other proceeding on account of malfeasance or fraud committed, he may, after giving the taxed person an opportunity of being heard, withhold the refund till such time as he may determine. 12. Where a refund is withheld under section 11, the taxable person shall, notwithstanding anything contained in section 56, be entitled to interest at such rate not exceeding 6% as may be notified on the recommendation of the council if as a result of the appeal or further proceeding he becomes entitled to refund. My lord, I will pause for a while. I say the cash lying unutilized in the electronic cash ledger is refundable under section 54. The explanation says the credit into the electronic cash ledger is credit to the government. 54:11 says if the amount of refund is withheld, then government is entitled to give me interest. So now, my lord, the proviso cannot be read in isolation. It has to be read in the total scheme of the act. 49, 54, 50, and if I go further, 51 deals with TDS. TDS deducted and credit to electronic cash ledger. Now I come to my income tax law, my lord. Just I cite an example. In income tax, advance tax I pay, TDS deducted, credit to my account. Ultimately, my liability come to 1,000 rupees, and there is a credit of 800 rupees already. I am to pay interest on the entire 1,000, or I am to pay interest only on 200. It's the same scheme. It's the same scheme in different
Advance
language.
tax, payment of advance tax is different from a credit available in electronic cash ledger. Is not one and the same thing.
My lord, my only point I am trying to make out, money goes to the government, it doesn't go to the government. The explanation says it goes to the government. Money is with the government. Now, money is not with me. It is not in my wallet. I am not withholding. If I am not withholding, I am not liable to pay any interest. Kindly see, my lord, the volume 2 comparison. Well, comparison volume 2. Page 46, my lord.
Page 46.
46, my lord. Volume 2. Prativa procedures. Supreme Court, my lord.
Volume 2, page number 46.
46, my lord. 46. And we are concerned with page 51, my lord. Page 51, para 13. Second para from top, page 51, my lord. Got, my lord?
Just
In fiscal statutes, the import of the words tax, interest, penalty, etc. are well known. They are different in concept. They are different concepts. Tax is the amount payable as a result of charging provision. It is a compulsory exaction of money by public authority for public purposes, the payment of which is enforceable, payment of which is enforced by law. Penalty is ordinarily levied on an HSE for some contumacious conduct or for a deliberate violation of the provision of the particular statute. Interest is compensatory in character and is imposed on an HSE who has withheld payment of any tax as and when it is due and payable. The levy of interest is geared to actual amount of tax withheld and the extent of delay in paying tax to the due date. Essentially, it is compensatory and different from penalty, which is penal in character. Then, my lord, kindly see. On judgment separately, I have said, my lord. Separately on judgment, I have said, my lord.
Associated Cement.
Yes, my lord, two judgments are there. Associated Cement and one judgment of the Allahabad High Court. 1 minute, my lord. Yes, I got it, lord. I'm sorry, my lord. Judgment of the first, I will take your lordship to the Bill Forge, Karnataka High Court. CC was Commissioner of Central Excise versus Bill Forge, Private Limited. We are concerned with, my lord, page
Just,
page 3, para 11.
just a minute. ये है क्या इनका? You have sent it separately when?
My lord, it was sent 2-3 days back, my lord. I think on
Day
Friday.
before yesterday, Lordship. They have sent it day before yesterday.
Today का कुछ निकाला हुआ है?
It has come through mail.
My lord.
December 20, Your Lordship.
Right. I don't think we have taken it out. Karnataka.
Karnataka, my lord.
Yes.
My lord, para 11 on page 3. Therefore, it is clear. Therefore, it is clear that liability to pay interest under Section 11 AB arises when the assessee is liable to pay duty on the date which is prescribed under Section 1 fails to pay the same. Then the liability to pay interest rises from the date of duty is payable till the date it is paid. By such late payment or delayed payment, the revenue is deprived of the duty. The said amount would be in possession of the assessee who would have the benefit of said amount. It is to compensate the loss sustained by the revenue. The interest is imposed. That is interest payable for the period during which the revenue is deprived of the duty, which it was legitimately entitled to. And as the assessee had the benefit of duty by not paying the duty payable on the due date, in other words, it is compensatory in character and is imposed on the assessee who has withheld the payment of any tax as and when it is due and payable. Then, my lord, page 6. Page 6, para 21, my lord.
Yes. Yes.
Para 21. Interest is compensatory in character and is imposed on assessee who has withheld payment of tax as and when it is due and payable. The levy of interest is on the actual amount which is withheld and the extent of delay in paying tax on the due date. If there is no liability to pay tax, there is no liability to pay interest. Section 11 AB of the Act is attracted only on delayed payment of duty, and where only duty of excise has not been levied or paid, or has been short levied or short paid, or else refunded, the person liable to pay duty shall, in addition to the duty, is liable to pay interest. Section do not stipulate interest is payable from the date of book entry, showing entitlement of submit credit. Interest cannot be claimed on from the date of wrong availment of credit, or that the interest would be able from the date submit credit is taken or utilized wrongly. So, my lord, what the legislature says that the nature of the levy of interest is compensatory in character, and the money which is withheld by me, on that amount only I am liable to pay interest. When the money in the stand case has gone into the government coffer, for refund of which I have to go through a process, he will consider and pass it within a time, stipulated time I have to file refund. And if it is withheld for one reason or another, then I am entitled to interest. That itself shows that the money is to pay to the government.
Mr.
And
Kudmi,
government is not
you see
entitled for any
the
compensation.
last 2-3 lines of this judgment of Karnataka High Court, which you have relied upon.
To understand that, my lord, I have to read a little bit of the fact. What happened in that case, the SSC took the credit and department denied it on the ground that you are not entitled to the credit. What the High Court is saying, simply taking of credit is not its utilization. So you are not entitled for any interest. That is what it is saying.
No, last 2 lines of para number 22.
22, my lord.
Yes, para number 22 of the judgment.
Last 2 lines, my lord.
Yes.
Then the liability to pay interest from the date the amount became due arises under 11B AB in order to compensate the government, which have
Without the liability to pay duty, the liability to pay interest would not arise. The liability to pay interest would arise only when the duty is not paid on the due date. So, the corollary question is the very fact that the amount has been credited in the electronic ledger, electronic cash ledger, will that amount to discharge of or payment of your duty of your liability on the due date?
my lord, that is a point. But there are 2 things. One, the date of payment of tax. Date of payment of tax. Your lordship is asking me specifically what is the date of payment of tax. My point is different. I am saying the interest government is entitled to or not. That is the only thing I am saying. When somebody asks me what is the date of payment of tax, then I would say the date on which I filed the return. But whether the interest of section 50 government is entitled or not entitled on the money already lying with the government. I am on that point.
That we have taken, your point we have taken, but we are not convinced with that point.
But Supreme Court Patiya procedure is very clear. It says the nature of tax, nature of interest, and nature of penalty. It very clearly says. It says the nature of interest is compensatory in character, and it is for the amount withheld by the SSC. When section 49 explanation says the money has gone to the government, I have not withheld it. When I have not withheld, I am not liable to pay any interest. There is one situation where I pay the amount of tax in cash after the due date, 20th of next month. That is different situation. But in a situation where I keep on paying the money regularly, or I pay before 20th of the next month, in that situation I am not liable to pay interest. That is my point. If I would have been paid the cash amount after the due date, things would have been different. But since in my case I have already paid the amount in cash prior to the due date, on that amount I am not liable to pay interest because I am not withheld the money of the government, and if it is not withheld, I am not entitled to, I am not obliged to compensate the government. Being the nature of levy, a compensatory one. That is my only submission as far as this interest portion is concerned, my lord.
So, according to you, if a person does not file the return at all and the amount is already there in cash ledger,
My lord.
then only the nominal penalty of late filing of return can be levied, and rest of the consequences has to there would be no other consequences.
My lord, my submission is that if any other penalty is there, or penalty or late fee can be imposed. But so far as interest is concerned, that cannot be demanded if sufficient money is lying in my electronic cash ledger.
And then that particular amount can be utilized for any transaction.
Transaction means not my personal transaction, only tax, interest, penalty, or fines or the charges. That much.
Certainly.
It's not my wallet I can use for any other purpose. I cannot withdraw it other straight away. I have to go by the law to get the money back from the government into my account. I have to file an application. He has to process the application.
When the government refunds the amount to an SSE, then the credit is through the electronic cash ledger, isn't it?
Not always, my lord. If my lord, there are two things. One, my exports are there, zero to supply. Then the money will come in cash to me. Inverted duty structure.
Export is a different thing altogether. That is, inverted duty structure is altogether a different thing. But under normal circumstances, if a person is entitled to refund under section 54, then the government would credit the cash ledger only, isn't it?
No, my lord. He will give the cash to me. I can apply to the government for refund of the balance lying in my electronic cash ledger. In my electronic cash ledger, 10 lakh is lying unutilized. I can file an application under 54 for refund of the same. 49(6) says that. And then that will be processed. And if that is withheld, then I will be paid the interest at the rate of 6%. So all these things reflects that the money, 49 explanation also says that money is with the government. And the interest is compensatory in nature. I am not liable to compensate the government if the money is already with the government. Penalties are different, late fees are different, though I will pay. Those things can be levied on me and I will be liable to pay that. But as far as interest is concerned, I am not liable to pay that. This is my submission on this point, my lord. One, show cause notice not issued. That is one point. Interest is compensatory. Second point, my lord. And my lord, third point, if my written notes you will also would see. The third point, my lord, I mean, is the D, last one, in my written notes, my lord. The propositions. Got, my lord? My written notes of argument, my lord. Page 4, the propositions are there.
Just So according to you, tax was not due on the date you filed the GSTR 3B return because it was already available on the due date in your electronic cash ledger.
My lord, if I would say that, that would be a wrong statement. Tax was, of course, due. Equivalent amount of lying in the electronic cash ledger, my lord.
No, so then what is the dichotomy? If the tax was already paid on the due date, being available in the electronic cash ledger, then there was nothing due on the date you filed the delayed GST 3RB return. And
In
therefore,
fact, my lord, what department is saying, respondent is saying, that on the day you file your return, on that day, this accumulation or credit in the electronic cash ledger was set off. It was debited. On that day, you paid the tax. That's what exactly they are saying. There is some small difference in this. I am saying that okay, technically on that date was debited, but money was lying with the government. So it is compensatory in nature. Date of payment may be later, but the
So-
interest is not payable.
the department says that since you filed the GST 3 or 3B delayed, there was no computation of the tax due till that date. And when you filed it, it was computed and then it was deducted,
Set off.
set off. So that's the catch.
Technically, my lord, compensation, it comes compensation. My point is that when it comes to compensation, I am not entitled to pay any compensation. But technically, late payment of return, filing a return, or any penalty for late filing of return or late payment of tax can always be retracted. I am not on that. Compensation of interest, I am saying I am not liable to pay. That is my point, is very limited to that. Rest all consequences will follow. So, my lord, kindly have page 4 of my written notes of arguments. Page 4, my lord.
Yes.
Propositions are there. Written notes, my lord.
Yes.
Page 4. Propositions at the bottom, my lord.
Yes.
Last D. Substitution of GSTR 3B from 1/7/2017 by substituted rule 61(5) does not make levy of interest retrospective. My lord, turn to next page. E, my lord, without without prescription of the manner of calculation of interest under section 50 subsection 2 of the JGST Act by rules framed under 287, demand of interest is illegal. In absence of computation provision, the levy of interest cannot be enforced. F, there is no substantive provision under the IGST Act 2017. Hence, by reference to section 51 of the CGST Act, no interest can be demanded. Last, my lord, the issue after issue of DRC 01A dated 28/1/2020, the respondent number 4 had become functus officio. Hence, issuance of DRC 01A 5/11/2021 again for the period April 19 December 19 without jurisdiction. The last point I will come first, my lord. Initially, they issued one DRC 01A for the period April 19 to December 19.
No,
That is,
this last point, where is it mentioned? I could not get that.
my lord, I will show you, lordship. My lord, kindly see
Page number?
page, my lord, page 75 of the writ petition, my lord.
No, not the writ petition. You were referring to the written notes of submission, no?
Yes, my lord.
Where is it
Page 5,
mentioned?
my lord.
Page,
Last point,
just a minute.
page 5. G
Page 5.
at the top.
Page 5,
Right up.
G.
G, my lord. Top, third para from top. After issuing first DRC-01A.
No, it is not matching.
Your lordship is having written notes of 161.
Yes, I'm looking to written notes of 1261.
Oh, 1 to 6.
Oh,
I
you
am
have
on
a different written
161.
note of 161 or what?
161, my lord. 3 separately I have given.
Just a minute. Why separate written notes have been given? Only the
My lord, in
way.
fact, the first repetition, it was all jumbled up. So separate repetitions were filed because it was very difficult to understand. So that's why, my lord, I did not club it again.
Okay.
So, my lord, kindly have page 5.
Yes, I've got that.
From top, my lord, third para G. After issuing first DRC-01A, dated 28/1/2020, the respondent number 4 has become functus officio. Hence, issuance of impugned DRC-01A 5/11/2021 again for April 19 to December 19 is not used. Initially, my lord, they issued one DRC-01A under Rule 142 for the period April 19 to December 19. That is on, my lord, page 75 of the petition. Demanding interest, my lord, of 86 lakh rupees. And how to know the period, my lord? The kind have to page 75. In pursuance of that notice, an order is passed, summary of order, page 73. Page 73, tax period, my lord, April 19 to December 19. Serial number 1, D. What, my lord?
Just a minute. Annexure 3, page 73. Yes.
This is DRC 07, which
Yes.
is passed in pursuance of 75, my lord, page 75.
Yes.
Period, my lord, April 19 to December 19. Now kindly have the supplementary affidavit, my lord. Now they started proceeding. They claim to have passed the order, amounts adjudicated as per them. Then again they are going back to 142. Kindly see, my lord, last 2 pages of the supplementary affidavit.
Supplementary or rejoinder?
No, my supplementary affidavit, my lord. Supplementary affidavit 6793 or 21. I'm sorry, my lord. IA. I'm sorry, my lord. It is IA. Last 2 pages, my lord, 34 and 35.
Yes.
IA 7. Kindly see, my lord, the period here,
Yes.
April to March 20. April 19 to March 20. Then they say this is consolidated and final calculation of interest of the financial year 1920. Again, they are saying you are advised to pay the amount of tax as ascertained above, along with the amount of applicable interest in full by such and such date, failing which so-cause notice will be issued under 73(1). So my point is that as far as April 19 to December 19 is concerned, they have already proceeded. As per them, they have already passed the order. So after that, the officer became functus officio. He could have very well done the same proceeding for the period April 9 20 to March 20. That he could have done, but he could not have gone back to the stage 1.
DRC 07 Annexure 3 is a result of DRC 01A Annexure 4.
Yes, my lord. And
Now that is for a period April 19 to December 19.
yes,
Now through the annexure IA by 7,
my lord.
they are again issuing DRC 01A for the same period and covering certain more period.
Correct, my lord.
That you say is not.
He cannot do that. He cannot go back
That is not permissible.
unless it is set aside. Now, my lord, in the same 5th page of my written notes of argument,
What has it entailed? Difference in the computation of tax?
yes, my
also?
lord, there is some difference in computation. And earlier it was page 73. If you lord see the petition, they had demanded from me. It was 86 lakh 24,000. Page 75.
Yes.
86 lakh 86 lakh 24,000. 617. Page 75. And now they are demanding 1 crore 11 lakh 25,984.
Because of additional period also, no?
Yes, my lord, period additional, and it appears to me there is some computation is also there. So whatever may be the reason, it may be more or less, but for the same period they cannot start the proceeding afresh.
And in your rejoinder, you have stated that you have paid the amount.
Yes, whatever amount was undisputed, that I have already paid in all 3 years. In 1 year it is 9,000, in 1 year it is 4 lakh, in 1 year it is more than 33 lakh. No? In 1 year 33 lakh I have already paid, my lord. Three period, three different amounts are there. Total 37 lakh. Total 37 lakh interest I have already discharged, my lord, as per my computation.
This is your point number?
G, my lord.
G.
So far as your reply to annex along with the counter affidavit is concerned, no dispute in regard to computation has been raised. Is that correct?
My lord, I am raising that there is no provision to demand
No,
interest from
that
me.
is a separate thing. It is one thing to say that there is no provision to demand this interest, but computation part is not in dispute.
No, whatever I accepted that I paid.
No, admission is another thing, but the point is that 2 plus 2 is 4. That part is not disputed. It is
No,
another thing to
why
say
I
that
did not,
it could be only 2 plus 1.
my lord, why did not I dispute that they are, the whole contention here is not that I am to pay 4 and I am saying 2. I am saying they are demanding on the delayed filing of return. That was the dispute. It is a legal issue.
Mr. Kurmi, the quantum which was not paid is not in dispute. The date of filing the return is not in dispute. So, and the rate of interest which as per the respondents could be charged, even that is not in dispute. So, if 3 components of a calculation are not in dispute, so computation as such is not in dispute. What is in dispute is whether in principle they could have raised this demand on account of interest. Am I correct when I say this?
My lord, why I am trying, what I am searching is that in all the 3 years, whatever I accepted, that I paid, rest I disputed.
No, you accepted the quantum of interest also for these 3 periods.
No, my lord, how can I accept, my lord? I have disputed all along.
Oh, then what have you paid?
The portion, in fact, my lord, as I have been arguing all along, that I have paid the entire money into the electronic cash ledger before 20th.
Tax due.
Sometime I have paid after that also.
Okay.
After 20th also I have paid. It's not that I have not paid thereafter.
Okay.
On that amount I have all discharged.
So the credit which you have made in the cash ledger post 20th,
On that I have paid.
on that you have paid interest, but
Yes, ma'am.
whatever the otherwise It is just the reckoning date of interest which would vary in some portion. But on the due date of filing of the return,
my lord.
whatever cash ledger was cash credit was available in your account, you say that on that particular amount the interest is due. That's
Yes,
it.
my lord. In this appeal rate number 177, 33 lakh 6,000 I have paid. And my lord,
Was this in this in the record where you have paid 33 lakhs, the entire amount to be discharged through cash ledger was already available in cash ledger, or it is just a calculation on interest?
after that
Those
day,
breakups are not there in the record. That is why
my
there
lord,
is
I
so
am,
much of
my
confusion.
lord, as far as the quantification is concerned, when the principle of law is settled, on quantification, whatever quantification they will do, there is no difficulty on that. I will not trouble
And
the
the
lordship to
quantification is
quantify the
automatic.
interest amount.
Mr. Kurmi, the quantification in the filing of return is automatic. You don't have to sit with a calculator and calculate, do you?
My lord, automatic. Yes, I am. That's why, my lord, I am coming to the next point. Kindly see, my lord, my written notes. My written notes, my lord. I am coming to E now. Proposition E.
No, Mr. Kurmi, if you have reverted to the written notes, why can't we proceed uh, from the beginning, one after the other, till the end, so that we get a comprehensive view of the.
Actually, what is happening is that there are certain points, a point of law or mixed question of fact and law, which are raised in the written note but not in the writ petition. So that is a difficulty. Even
No,
the
there is none, my lord. There is none.
document.
No, no, no. It is not, my lord. It is not there. I can show each and every.
So instead of referring to we are taking extensive notes, Mr. Kurmi. You can refer to the documents, pleadings in the writ petition, because we decide cases on the basis of writ petition, not on the basis of written notes. Written
My lord,
notes is basically for our convenience. You can refer to the writ petition and whatever you are arguing, we are taking our notes.
only for your lordship's convenience, I made written notes, my lord.
That's
But
right. So
all
you
the
can
grounds are there
refer,
in
we
the written
are
petition.
understanding every word you are speaking. You can refer to the writ petition and argue your case.
The only thing which you could have added more to the written notes was the reference of the relevant ground or para dealing with the grounds or the facts in the writ petition or the other affidavits filed for easy reference so that we would not have to revert back to the pleadings again and again. That exercise is missing from the written notes.
My lord, as far as interest on delayed filing of return, kindly see writ petition page 41.
So what we do, Mr. Kurmi, um, I just want to ask because today the State Council, are you ready today? Mr. Kurmi, you are not going to conclude today perhaps.
No, my lord, it will take some time.
Will we continue tomorrow? Are you ready to reply to the points raised by Mr. Kurmi? You have to unmute yourself, Mr. Yadav or Mr. Deepak Kumar Dubey.
Let them conclude, my lord. We will respond to
Your other system might be working. Close the other system or mute it. Go from your side. You have heard our query.
Yes, Your Lordship.
So suppose we continue because I often feel that when we are hearing a case argued by Mr. Kurmi, this should be the only case which we should take up throughout the day instead of getting mixed up with all first appeals and suspension matters. Such disjointed thinking doesn't help.
My lord, if they will if Mr. Kurmi conclude tomorrow, Your Lordship, then we will reply on the next year, Your Lordship. That is in
You can
January, Your
reply.
Lordship.
You see, he has almost. You see, he has put all the points.
My lord.
You can reply in continuity tomorrow, such that we can reserve the judgment and deliver the judgment in proper time. Then you have vacation, and we also there are so many things, intricate things which you also miss and we also miss.
My lord.
Yes, Lord, that can be done.
Mr. Yadav, you are also. Both the state councils are going to address on the reply, or anyone will lead the argument for the state.
My lord, any one of us will lead. My lord, today Mr. Sachin Kumar is out of station.
Mr. Ashok, Adel, you have joined from two different lines.
He's attending to 2 and more courts perhaps.
No, it's all closed.
No, even in the you can see that you are connected at 2 points.
Even this court perhaps he is connected
Yes.
from points.
In this court, is connected on 2 points.
From my side, it is only one connection. I don't know why it is.
You just see the persons joined. I can show you from there. You see Ashok Yadav, twice you have joined. It is showing from at the bottom you will find the list of the persons who have joined and your name is reflecting twice.
Sister has become too tech savvy. So,
My lord, in item number 29, Your Lordship, Mr. Sachin Kumar will assist Your Lordship. But he is out of station, Your Lordship. For that reason, I am praying for.
he will not be able to reply then. No? He has not heard the argument.
Yes.
Dubey, you don't take things so lightly. Okay.
Mm,
If a counsel who has to reply, he should hear the arguments.
my lord.
He will reply in his own manner without referring to the arguments of the counsel for the petitioner.
And it's a very, very subtle points have been asked. In fact, it has taken a while for us to register those
Yes.
subtle points.
Because from the records, Mr. Sachin Kumar will not be able to register it.
No, in item number 29, I am, Your Lordship.
But all the matters have the same issue.
Both matter are tagged together, Your Lordship.
He is additional advocate general. He is supposed to lead the argument, or it will be left to Mr. Ashok Yadav to lead the argument.
Yes.
Who will lead the argument? We want to know from your end.
My lord, in item number 28, Your Lordship, Mr. Ashok Kumar Yadav will lead.
Item wise, no, the issue are the same. You just let us know who will lead the argument from the side of the state.
My lord, definitely Mr. Ashok Kumar Yadav, Your Lordship.
Yes, my lord. I will lead, my lord. If Sachin Kumar is not present, I will be there. To assist Your Lordship.
CGST is also a party or what? From the side of CGST, who will lead the argument? Because the interpretation of section 50 is involved. Suppose we interpret it in one way, then that interpretation will be binding on CGST.
Unmute yourself, Mr. Amit.
CGST is not a part.
Mr. Amit Kumar is here.
Let's say CGST is a party, Milord. CGST is a party.
Lordship.
You will argue, Mr. Amit Kumar. Your taxes or your interest and tax is also involved in the
I am
interpretation.
appearing in two of the cases, Lordship. 161 and 177, Lordship. And 1261 is with Mr. P.S. Patti, Lordship. In that case, counter has been filed, and that is the leading case, Lordship.
According to you, which is the lead case?
1261, Lordship.
1261. So Mr. Patti will be leading the arguments because he has filed a counter affidavit,
Yes,
right?
Lord. Yes.
So two arguments, one by Mr. Ashok Yadav, then the other one by Mr. Patti.
Lordship.
Then what do we do, sister? Should we continue tomorrow?
I am absolutely clueless, Lordship. This is, the councils are not serious about their cases, or they have too many cases to argue. In a case like this, we have spent half of the day.
And that is why we finish off rest of the matters quite quickly so that we can devote enough time.
Lordship, we can do one thing. Tomorrow we can ask the council for the CGST to advance their argument and figure out as to what is their argument on this.
But Mr. Kurmi should finish off other points also so that
You should finish off.
uh,
You should finish off what
for us, for our consumption also, we get a complete view of what he has
Yes,
to
Lordship.
add more.
That's correct.
Difficulty is that tomorrow also there are so many suspension matters and other things. And probably there would be some meeting also.
Yes, Lordship.
1, 2, 3, 4, 5, 6, 7. 7 suspension matters. Then 2 LPAs, other tax matters, 2, 3 tax. Polycap, that advance ruling is also there. The only concern is that we will lose thread of the argument once if spills over after the vacation and then have to catch up again. Tomorrow is Mr. Kurmi would obviously conclude, but with the rest of the respondents, it's not sure that they would be able to address us. Their preparations may not be there. Mr. Kurmi, would it be fine for you to continue tomorrow or just after reopening resume again?
But I can do it tomorrow.
The only thing is that whether we will be able to give you enough time because tomorrow's list is also loaded.
And tomorrow we are not online. Tomorrow is a physical day.
Tomorrow is a physical day.
We'll have to come physically to Ranchi to argue.
So, Mr. Kurmi, you won't be able to come tomorrow physically, isn't it?
Yes, my lord. Tomorrow is not possible, my lord.
So, if we keep it in the reopening week, then again you will insist on a virtual day or you will be able to come physically?
My lord, I will grateful, my lord, Civil Lordship can accommodate me in virtually.
Mr. Kurmi, we just have only one day virtual on Wednesday. And you see the kind of issue involved in this case, it may spill over to the next day. If you come on a Wednesday, if you argue on a Wednesday, we will be absolutely not, it will not be possible for you to come on a Thursday. But we will continue on Thursday. Then your junior will have to take down whatever he has to take down the notes. Because these matters are required to be heard in continuity in order to have a good judgment.
My lord, the first day.
Or you can have Monday and Tuesday.
What I was, my lord, my suggestion, not say. On Wednesday, the first day, let it be the first day, the Wednesday. In the evening, I will make a ticket for Ranchi. I will come down to Ranchi. Next day, I will be there physically. So that these 2 days can be covered this way.
Very well. And of course, we are not sure that in the reopening, after reopening, whether this 3:2 ratio will continue or all days would be physical.
We don't know what would be the constitution, and we are not sure.
We keep it on 5th of January. Ideally,
My lord.
it could have been 4th would have been better. For that, you will have to come here, and if you are here on 4th, you can as well address virtually on 5th if it is a virtual day from Mr. Pasari's office.
So, my lord, your lordship is giving 4th.
Or Melons, we can request that to take up the matter physically, this particular matter, after the online hearing.
You mean to say that?
Subject to Melons,
No, you mean
both
to
the
say
days
that Mr.
physically.
Puri available on the physical day?
Melons, that I will ensure that Mr. Kurmi is here only. I will not let him leave Ranchi until unless he finishes the matter.
In that case, we can keep it on 4th, and 4th is a physical day, Tuesday. If it naturally continues, then on 5th we will continue in either physical if it is so, otherwise virtual.
So, 4th and 5th, my lord.
4th and is that fine, sister?
Yes, Lordship, perfect.
Provided the same bench is continuing.
Lordship, it can be treated as a parthad. We have heard it for so long, and many things are cleared in our mind. I leave it up to
Difficulty would be generally I don't keep matters part-heard because constitution of bench and the parties are put to a lot of trouble. Our convenience if we are sitting separately, then breaking of the other regular
If
bench.
the bench changes, they will argue all over again. For them to see.
Keep it on Tuesday. Or keep it on 5th and you can come on Thursday, Mr. Kurmi, which would be more convenient.
This will be more convenient for me, my lord.
Okay. So keep it on 5th. Then counsel for the petitioners, Mr. Kartik Kurmi. Give your appearances, counsels, has advanced his submissions for further submission on his part and reply thereafter on the part of the state and the CGST. The case on 5th of January 2002. In that case, if Mr. Kurmi, your office gets time, then the written notes can have this in bracket along with the paragraphs as to which ground in which writ petition and what is the para number so that we don't have to doubt as to whether it is within the pleadings or outside pleadings and check. You have to unmute yourself, Mr. Kurmi.
My lord, may I revise my written notes?
But send it, if you can do so, send it by 25th, 26th, so that during the holidays we get, on reopening, we may not get much time.
And Lordship, the respondents have not done any kind of. They have not sent any judgment or any kind of note from there.
No, they will, don't know
They may
about
not,
some,
they may not, but the point is that they have not done so far.
no, because it's an interpretation of a particular, and not only a provision, but in the context of the provisions of the Act,
That's right.
and also the nature of the interest, compensatory and all which has been argued.
Yes, certainly.
They need to be prepared more.
That's right.
Very well. 36 remains as a passover for the day. That and cash.
Last item, my lord. Last item.
Yes, last item.
My lord.
Worship, in that case, the respondents have already withdrawn the show cause notice. And Honorable Gujarat High Court has passed an judgment where the show cause was absolutely vague and had directed for their training. I'll send that order to your lordships.
Okay.
In that case, also the show cause was vague. So, and now respondents have already withdrawn the show cause. They may proceed as per law. That is the only thing we can contemplate in that.
No, my lord. There are two show cause notices. First, they issued one show cause notice on 7th June, and that they withdrew.
Okay.
They revised a new show cause notice, and they issued on 14th June. That they have not withdrawn. So 7th June, they have in the counter affidavit, they have said that they have withdrawn. 7th June is now gone. But 14th June, that remains. The same way,
So both the show cause notices are under challenge.
yes, that was under challenge. In their counter affidavit, they have said that no, 7th June show cause notice we have withdrawn. So one show cause notice remains.
Yes.
Mr. Kurmi, you have seen that order of Honorable Gujarat High Court regarding that direction to train
Yes,
authority?
Yes, my lord. I have seen, my lord. My lord, sincerely saying, it requires some training. Because in the central excise regime also, many show cause notices failed. Because of many wrong show cause notices or vague show cause notice, demand ultimately failed in Supreme Court.
That's right.
So, and in
That
central
doesn't serve anybody. Vague show cause notices does not serve anybody.
So, my lord, in cell tax and VAT regime, this state authorities never had occasion to issue show cause notices.
That's right.
That is, but central excise authorities, they are very much well versed with this. So, whenever they issue show cause notice, it is an elaborate show cause notice.
That's right.
So, they have been given good training over the period because they have suffered a lot. But the same training must go to the state authorities also. In all the
Training,
states,
you see, the central excise had their own formats and all circulars as to how show
correct,
cause
correct, my lord.
notices,
Yes, my lord. Yes, my lord.
what all are the contents of the show
Correct,
cause
my lord.
notices. But those principles are not there, not percolated to the state authorities.
My lord, my lord, my lord. One
So,
circular of
a
105.
classroom of training is required.
One circular of 10th March, I had enclosed, my lord, central excise authorities. That
That's
was the purpose of enclosing that circular.
That's
Because it has in one place, it has summarized the principles of issuing show cause notice.
That's
From different judgments, it is taken and put in one place. That was the purpose of putting that circular.
If not the circular, at least the principles would apply.
My lord, in the Gorkha Security Services, the Supreme Court has said what the show cause notice must contain. The Supreme Court judgment I have mailed to your lordship. In that case, I will.
Gorkha Securities was in a different context altogether.
It was in the tender matter blacklisting.
That's right.
But the court said what a show cause notice must contain. Because now show cause notice is a facet of Article 14 and natural justice. So the principle will remain the same, whether under tender or maybe under the central excise or the GST.
Right. The content of the charges and also the proposed penalty.
Yes, my lord.
Exactly.
and metal forging, all Supreme Court had the occasion to say that any correspondence, any letter exchanged with the party is not so cause notice. So cause must be in a different format. And your lordship also in the N case has said that summary to so cause notice is not substitute to so cause notice. Your lordship have already held.
So, Mr. Kurmi, for you, Happy New Year, because perhaps we won't be meeting this year.
Very happy New Year to my
Happy
lordship.
New Year, Mr. Kurmi.
Thank you.
Thank you, my lordship. Same to your lordship. Very happy New Year.